Hey everybody, and welcome back to Sloth. I hope you've been doing well. So today we're going to get into something called the year and the day doctrine. It's an old common law defense to murder. And we're going to do it through the case of United States v. Jackson from 1987. But before I hop into the actual discussion of the case, I just wanted to say thanks to all of you that have subscribed so far. I'm actually up and over my first 10 subscribers, and I am tickled beyond belief. So thank you very much and welcome. It's been great to have you, especially those of you that have reached out and started commenting on the various videos. It's been really nice to chat with you. And if you're new to my channel, if this is your first video, then go ahead and hit that subscribe button and join the party. Hopefully you'll enjoy yourself. So let's go ahead and get into the video. Walter Bloss was unfortunately shot in the back of the head during a robbery on January 2nd, 1982 in Washington, D.C. Unfortunately for Walter, he got to the hospital and he stayed at the hospital, but he never left the hospital. He was there until he died 14 months later after the assault. Now that 14 months does actually matter, and you'll see why in a little bit. Ricky Jackson was arrested for the robbery of Walter Bloss, as well as several other charges. And when Walter died 14 months after the incident, the government went back to the judge and added an extra charge, that of second-degree murder. Now, the trial judge looked at the facts of the case and said, it's been 14 months since the shooting took place. The year and the day rule apply in this case, and I'm dismissing the murder charge. After some procedural snafu, thanks to the Christmas holidays, the prosecutors appealed this decision, and going up the chain is how we got to the case that we have now. Now, that 14 months that I mentioned and said was so important is because of the very definition of the year and a day rule. The rule says that if a person survives a year and a day after the injury, you cannot charge the perpetrator with murder. It's no longer a murder. At that point, you would just rely on whatever underlying crime was left. For example, if I hit you in the head with a brick, that would likely be something akin to assault with a deadly weapon. In the case, the judge did what judges love to do, and they went looking into history, particularly when you're talking about common law defenses. And the year and a day rule has a long history in common law, going all the way back into the 13th century. Moving forward through time, by the 18th century in England, the year and a day rule had established itself to basically mean that the assumption was you could only bring a murder charge if the victim of the act died within the year and a day. And because America started out as a British colony, we had their common law as our law, and this particular defense was part of our legal system. Now, fun fact, the law in DC is a little bit different because DC is a little bit different in the way it's set up. As most of you know, the District of Columbia, the capital of the United States, is not a state, and it's also not strictly the federal government. It's its own unique jurisdiction, and as such, the law tends to be a little bit different than you see otherwise. And in this particular case, in 1987, the law in DC was still all of the common law in force in Maryland in 1801. Including this doctrine of a year and a day, unless it had been later expressly repealed or modified. And in some instances it had, with new laws and changes over the subsequent 200 years. But no one had expressly gotten rid of the year and a day rule. And because they hadn't done it explicitly, it still existed in 1987. So the judge took a look to see why this doctrine was in place, because the why matters. And unfortunately, no one really knows. We guess, we think, but we don't know for sure, which, given it's from the 13th century, no one should be really surprised. The best guess that the court was able to come up with was that it was a causal relationship issue, or they wanted to, as closely in time as they could, tie the action and the result, also known as the hitting over the head and the dying, or the poisoning and the dying, or the trampling you with my horse and dying. Because the theory is, and it makes sense, the longer you go between the two components, the action and the result, the more likely it is that something in between actually caused your death, not the hit on the head or the poisoning or Mr. Ed having a bad day. And because murder is the intentional killing of another with the intention to do so, depending on how you phrase it in your jurisdiction, if the action that the person doing the hitting took didn't actually kill you, then they're not a murderer. It might be assault, it might be attempted murder, but it's not murder. And so that causal relationship was important, and as a result, they came up with this particular rule. Now, the judge in this case sat and looked at that and said, it makes sense, and it does. Back in the 13th century, 14th, 15th, even early 20th century, the medicine wasn't there, the technology wasn't there, the science itself just didn't exist in the way that it does now to be able to show time of death, to show cause of death, to be able to extrapolate out the tie between the action and the result, or the hit on the head and the death. The court said that's not the case anymore. We have the medicine, we have the science, we have the technology to be able to make those causal links, to be able to join those actions together in a way that they couldn't before. And so the underlying assumed reason to have this doctrine no longer really existed. And because public policy also does creep up in the law, the court took a look at public policy reasons why we ought to keep or get rid of this particular defense in the District of Columbia. And the court basically adopted two public policy reasons. They said, one, that it would seem kind of strange that killer ought to get a pass on being charged with the crime just because the person managed to survive. When murder is considered such a bad crime, it's so heinous that there is no statute of limitations for murder in the District of Columbia. Additionally, it also fails to take into consideration the changes in technology and what that would mean for a defense like this. Medicine is really very good, and we can keep you alive after something very bad happens to you for a fairly long time, often. So it also wouldn't seem like the best public policy decision that a criminal should get a pass just because a doctor is very good at his job. So the judge took a look at the totality of these circumstances and said, no, it's time for the year-and-a-day rule to go away. And that's exactly what he did. The judge said that in this particular instance, abrogation of a year and a day was appropriate. Now, abrogation is just a fancy way of saying annulled, abolished by order. So instead of the legislature repealing the law, the judge went ahead and just put the kibosh on it. And the judge said that it's actually for the legislature, not common law, to determine whether or not there should be time limits on something like a murder charge. So, what happened to Jackson? Well, he got off on the murder charge, but for other reasons. And I'm not going to really go into those. The citation is in the description. And if you're interested, you should go take a look. If you're a criminal procedure nut, you would actually probably enjoy this. There's collateral estoppel and double jeopardy and ex post facto and all sorts of things. Again, not all that important for the concept of a year and a day, but that's the case. The year and the day doctrine, the length of time it took where it was no longer murder, is no longer the law of the land in the District of Columbia. So I hope you enjoyed the video today. I certainly did. This is always a fun topic for me. If you did enjoy it, please hit that like button, hit the subscribe button. It really does help with the algorithm so that more people get a chance to see my videos. And guys, do reach out to the comment section below. I'd love to hear what you think. Until next time, I hope you have a very good weekend and a safe Memorial Day if you happen to be in America. All the best, everybody.